So, Honorable Ssemujju, I must commend you. Yesterday I saw a video clip of you for once not fighting and for once stopping people from fighting.
Oscar, you have never seen me fight.
You have that time in Parliament, I think you were.
I have never. I am always beaten.
you are being beaten perhaps because you are in the fight. But yesterday I saw a clip of you and you were really near an elderly MP stopping people from fighting.
When SFC raided Parliament in 2017 during the constitutional amendment that removed the age limit, I was the first to be dragged out. Why? I was asking policemen not to beat Odongoto. Instead of welcoming me, they grabbed me. I was the first to be grabbed. First of all, my name was never read. So you've not seen me, Oscar, fight. I don't. In the case of yesterday, we were outside because court hadn't started. And then I heard a noise, and through the window I saw the fighting. So I went to stop the fighting. But the reason it happened is that I am still investigating, but I am closer there. I think because the Crime Intelligence Department of Police, headed by Brigadier Damulira, has recruited and works with the Chiefs. I have personally asked Damulira myself, and he said if you want to fight crime, it's important to recruit people who either have been involved or who are involved. That's when you can fight crime. And it made sense when I interacted with him. The unfortunate thing, he also got tempted now to deploy criminals, because the first justification was that you recruit them to fight crime because they know the ins and arounds. And when I interacted with him some time back, I understood him. But now they have recruited them. I think now they are a league. I don't know when are elections for the Chiefs League of NRM. They come to court in their tens. The idea is that they should fill the courtroom, say that those of us who come for message, by the time you arrive, there is no space for you. And when you are standing, the police that is in charge of security in court will ask you to exit because you have no space. So that's why they come early. Yesterday I was told by the boys who arrived first that they brought them in drones, about 60 of them. Others are stationed outside. So when the real PFF SJ people entered court, they found them. And they are not policemen because they are dirty. You can see them. So they said one way of identifying them is to begin photographing them, because for us we get photographed. They were jittery. Why are you photographing us? They attempted to grab a phone from Ingrid, and then the boys snatched it from them, and that's when the fighting started. The interesting thing, the one who looked like a policeman, I later spoke to him. When he was fighting, I think he didn't know all of them. He was also kicking them. So he kicks our people, he boxes their face, and some of them actually ran out. I think they later retweeted and said the people you are beating are ours. So the police around the court came in. They were also reinforced by the police that was outside. But they knew that these people had come in. That's why they did not arrest anyone, but they witnessed the fighting. Instead, they were just stopping the fighting, and these guys, one by one, moved out. The one who looked like a policeman told me the reason we are here is that the co-accused is a soldier. So my understanding was that maybe he was military, but later I learned that he's actually CID, is not part of the military, and his intention was to lead this group of the Opondo to enrich face, so they feel caught.
But do you think you're the one who loves to follow the proceedings of the prosecution? And other Ugandans should be free, even if they are not PFA.
Yeah, but you see, if you are any other Ugandan in a courtroom, that's why the lawyer was telling the magistrate, the law allows anyone to be photographed and filmed. If you are a bona fide person, you cannot fight because they are filming you, because you will get filmed.
Especially if you're in a public place.
Yes, and in the courtroom, not even outside, but in the courtroom. So why do you fight? Opondo? There is no way, because you have been attending that court for now 6 months. There has never been a fight until, because initially when we had the army, the lawyers complained and court asked the army to leave court, and they left, at least those who were in uniform. Now you have another army of which face, dirty, dressed like they are, I don't know, and they don't want to be photographed, they don't want to be filmed. So I don't know, maybe I intend to write by the way to the judiciary to ask them if it is no longer safe for anyone to attend court. Because the appearance of BSG on 21st, these people filming in court, because they coordinate with the security outside the court, they kidnapped 2 of our boys, including one who is a leader in my constituency, Nari Katongole. They snatched him, put him in a drone, beat him, and eventually abandoned him on the bypass. There was another guy also from Kawembe. Because when we sing, this is a political case, we sing and welcome BSG singing.
But if the magistrate can stop you from singing.
No, you cannot you cannot sing when the court the court session is started. Okay. So you sing before and when court has ended. And we've done this since I joined the politics. I saw it happen. Court has no issues with it because they will knock at the door that the magistrate is arriving.
Taken from South Africa.
Yeah.
So anyway, we'll discuss a little bit of that in our next topic. Let's go to the UPDF amendment bill that you passed. So what did you pass?
That Parliament passed.
You are the MP in the studio.
Yeah. So are you going to be responsible for everything we say here?
In the studio you are the MP.
Here the radio station radio station is to say that they will put a disclaimer that the views expressed are not necessarily the views of this station. Well, so the bill that was passed.
Let me first tell Michael and Jacob that Star Cafe is here. You don't need to carry a chapati in your pocket. Everything is okay. Things are not being eaten for a while because all has been missing. So today there will be a larger clearance.
Thank you. So let me fix the coffee.
Okay.
You see, the bill was more than 83 clauses. Many of the things are administrative issues of welfare, soldiers who have had problems, and then the issues of validating some illegalities. For example, the Special Forces Command has been an illegal outfit since inception. Now they elevated it to a level of a force, equal with the Land Force and Air Force, and made it formal, because initially it was a Museveni militia. He knows who he recruits there. I have personally complained. It has been
your pet subject for a while.
Yeah, and because it was illegal, it should have been a pet subject for everybody. They validated it, but also created the reserve force. I don't know why the reserve force now becomes part of the forces in Uganda. The implication, because usually it is people who have retired in the army that are in the reserve force, perennially commanded by Sare. I don't know if he has now left, because it used to be Sare and any other person.
It is now General Otema Awan.
Yeah.
He has been there for a while, actually.
After retiring.
No, Otema Awan is not.
Yes, so now it's being commanded even by people who have...
I can see the MP is not adequately informed.
It is possible. You cannot be informed about everything of Opondo. In fact, if you claimed, you would be stupid. That for you, you're informed about everything.
But and you have just passed the law.
The issue is not who commands it. I am just telling you that the reserve force has also now become a force together with the Land Force, Air Force, and SFC. So those were some of the clauses that were passed. But the contentious ones were the issues of reintroducing the military courts and then providing for how people sitting on those military tribunals will be selected in consultation with the Judicial Service Commission and so on and so forth. So those were the contentious issues. The only change that was effected was on the military store, the uniform. I think it must have been in Sereko who moved that even if something looks like a military uniform or a beret, as long as it doesn't have an insignia, it shouldn't be considered one. So the only addition was the insignia. So, but there are the published photos of everything, including ordinary shoes, and said all this is military store. So Oscar, that's what was passed. More than 83 clauses were passed by Parliament, but we were out at the time all that happened. Because you see, the whole process, they did it in a military way, bring a law, someone people to come and appear before the committee in the night, and they are required to appear in the morning. It was just a ceremony. But even when they went for the actual meeting in Munyonyo, first Baka Mugabe was chairing the legal committee and defense. He adjourned the meeting and said, you guys, meeting adjourned, and said, we will call you. Then within 6 hours, he had called them, not for a meeting, but that we are going to Munyonyo to write a report. In Munyonyo, during the joint committee meetings, the first contentious issues that the committees were voting on were the names of members of High Command who were members of High Command as of January 1986, Saleh, Museveni and others. So the MPs, including NRM MPs, voted that those fellows should leave the law. They don't have to be there. Then they went to 2 other clauses, and the MPs were saying no. What the chairperson did was to go for a break because he was losing. When he came back, he said, we have been called for the NRM meeting. Then the whole bunch of NRM MPs left. When they came back with a report towards 4 a.m. in the morning, a report signed. So when our colleagues were in Munyonyo asked them, where did you sit to consider and sign the report, that we are signing from the office of the committee chairman, others signed from Entebbe. So the seconders didn't sleep. They were hunting down NRM MPs until they saw them around 3, and also prepared the minority report, which they brought to Parliament. So really, this whole process was like a game. You look for NRM MPs, they have run away. But for me, I'm familiar with the budget. I go through that. You are in a budget committee, but a report is being written by someone else, and the majority of the MPs, nearly 90%, will append their signature on a report they haven't even read through.
So, I mean, what for you, Honorable Ssemujju, what are the contentious issues that led you to walk out of Parliament?
The walking out was a protest against Parliament overthrowing its own processes. Because in the laws that we've been considering, and this particular one where I've even spent money to publish adverts in the newspapers calling people to come and bring views, because almost all the contentious laws, and I am speaking with a lot of experience as a journalist and as an MP, you will have Uganda Law Society Law Reform Commission, you will have political parties, you will have everybody, because there was also a law on political parties. People were receiving invitations at 10 in the morning, and you are required to appear 30 minutes after or later. So we are protesting that we are not following the procedures and practice of Parliament. For all the bills that come before Parliament, if you read our rules, the requirement was not for a ceremony. The requirement is that because the legislation is a very important matter, making a law that is going to affect everybody. The basic requirement in the rules is that when you present a report on a bill, you will not commence debate until after 3 days. The 3 days you have to allow the MPs, those who bother, because majority, especially in Ireland, don't read. They are like animals. The moment you unleash them, they come. I told you a story of an MP who came with his hand up, Billy Mumaso. They told him the NRM is now voting. So he came with the hand up. They told him, no, we haven't started. So that's how NRM MPs conduct themselves. But the idea is that allow 3 days people to read, understand, conceptualize, come and legislate for the country. But this one, all those rules were, because we knew they had proposed so and so you remove that, we suspend. So and so you remove that, we do this. So the protest was because the processes of registration had been overthrown by the Speaker and the entire NRM machinery.
And the court martial? Courts martial?
No, we didn't go into the content. The content, as I told you, the bill was passed almost as it was presented, with the exception of adding removing or adding the word insignia. So if a Kaunda suit looks like the one of UPDF, as long as it doesn't have the military insignia, so you will not be, okay, the assumption is that you will not be arrested, because they can still arrest you.
Yeah. Let's go to the elderly here, Opondo. Yes. What's good about that amendment?
I have been in the election 20. I didn't follow much, but this is an old bill. It has been in that parliament since 2020, the UPDF amendment bill. Now, when the Supreme Court, the famous ruling was made in March, January, government sought to rectify what the court had found as an anomaly or gaps. And so it brought in elements that talks to the ruling about the jurisdiction, the power, composition, tenure of the court marshals. And the MP, as usual, particularly from the opposition, decided to cherry pick the focus. The bulk of the bill talks about reinforcing administration and welfare issues, like Honorable Ssemujju has glossed over. If a soldier is injured, presently, a soldier is injured, he gets away without any compensation. Now, this bill does introduce that, and I think it is a good thing. It is important for our service people who get injured in line of duty to be fairly and adequately compensated. Secondly, the formation of the gratuity, removing it from the mainstream civil service to adapt to a new specialized body that deals with pension for service people who have been in service. Third, Ssemujju may have issues, but the army is an organ. The army is an organism, you can call it. It ought to grow. This UPDF started with 42 people armed, 27 of them armed, and has grown. And therefore it must be alive. Consequently, it expands. And when it expands, it is necessary that we formalize that process of expansion, because there are things that we can't foresee. This SFC, Honorable Ssemujju has issues with. It started just as a protection unit for the chairman of the NRA in the bush, something like 7 people, guarding the chairman, the person who was leading the guerrilla war. Now, it is a government army. It came as a rebel force. By legal notice number 1, it became the National Army. And it has gone and undergone modification to rhyme with the times and the tasks that has. So I think I have no issues if PPU, the guard unit of the chairman, high command of the chairman, the PPU, the PGP is now a force recognized in the law. For me, I think it's a good thing. When the army was started, we never used to call publicly for recruitment. It was just the army leadership that says goes out sourcing people. I remember in '87, these LWLs, we went to university with Makerere, and we just sourced people who were willing to join. I remember it was a tug of war to convince somebody from Teso, to convince somebody from Lango, to convince somebody from Acholi, to convince somebody even from Toro here to join the army, because they're saying, first of all, this government will not last. This is their army. So we went deliberately sourcing people to join the army, to join ISO, to join the ESO, and so on and so forth. So today we are at a stage where Ugandans, when you call for army recruitment, you have been overwhelmed. And so the law to create the different branches of the army is a good thing. Uganda is not an exception in having reserve force. The world over, all the countries that I know have a provision for reserve. Either Uganda you do a training and a stint, maybe 9 months or 1 year, depending. In some countries, there's even a conscription, because not all people who retire from the army become useless. They still have expertise. They may not hold the gunfight, but in times of war, when we really need people, you will need drivers, you will need people to manage the stores, you will need all sorts of people. So it is necessary to have that reserve force. and the current commanding general of the reserve force is General Otema Awan, still a serving officer. And so that expansion is good. Now, about the court martial, I have not seen the details, but there is a complaint from the Ssemujju that that the government has not complied. In fact, they're saying they have reenacted what was outlawed. I have not read that, but from what I read, now the court martial has been reinforced, actually reconfigured. The composition now has people who are lawyers. Their appointment is in consultation with the Judicial Service Commission. They have also tried to equate the first court to a magistrate court.
No.
What they have tried to equate with the civilian
They haven't.
with the civilian courts.
They have actually created a court martial at the unit level.
Yes.
Then we have the next level will be at the division.
Yes.
Then we get to the general court martial. Then they've also provided the amendments also provide for appeal.
Appeal. So
You see, if a second, you see, because the law was done in that manner, the only provision they made is that you can appeal to appellant court. Later, when we are raising this matter, the Court of Appeal can only hear cases that are from High Court. So even that, because of the manner in which they were hearing.
Anyway, even this law,
case.
this law has provisions for amendment. If there is a lacuna or overlap, I'm sure the Attorney General, the Minister of Defense will come back to Parliament. Now, Honorable Ssemujju is having issue. Your rules of Parliament, rules of procedure, provides instances when rules can be suspended, and that's how the 3 days does not apply when there's an emergency. You want to treat an emergency, somebody moves a motion to suspend a rule which says you have to lay matter for 3 days. Fourth line, which I want to conclude with, Honorable Ssemujju is saying that they moved out in protest of procedure. The Honorable Ssemujjus are known to walk out even when the procedure hasn't been abrogated or overruled. You have seen them walking out each time the president comes. This is a constitutional command that the president addresses State of the Nation to Parliament. The Ssemujjus walk out.
Me, I don't attend. I don't walk out. I don't attend.
They walk out. And so their walk out, this is simply a lame excuse. And Ugandans, I think, are now used to those lame excuses. Each time they face defeat, they will have a reason to walk out or to stage a fight, a fracas.
I thought Opondo you're going to be a value addition to Parliament.
Because I'm now going to face you on the floor.
So you're going now to propose that rules should be suspended.
where you now seem to monopolize wisdom. I want to come there and face it in the floor.
Michael, I am not so sure where Abdul has disappeared to, but you are the lawyer in the studio.
Yeah.
Whatever OO may say, the president may be on Ssemujju's side, because President Museveni is particularly pleased with the court martial, whatever was passed by the court martial.
The president is saying, without the court martials, the way the executive thinks, discipline would fall apart in the army. Imagine, because this is the case he's giving, say, if somebody steals ration is a dry food, supply food made for soldiers or uniforms. Supposing somebody steals food in a war station, because they know Honorable Justice or when you don't court probably will be laxed. Now we want fast, instant but fair justice within the army.
Boys who have been before the court martial for 4 years steal food.
No. And
they could have connived with the soldiers.
It's good you're maybe when you get to Parliament you leave and draft a few lines for him, because for him is clear. He says, you judiciary, you work with corruption cases and whatever, leave these other ones to us. That's his line of thinking, Michael, isn't it?
Yes. Now, you clearly state that the president was pleased with the passing of this particular law. You see, we are in a political period. We are headed to the polls. And whatever you see the opposition doing is basically revolving around politics. Because now they're trying to make their case.
And NRM.
Revolving around.
Even the NRM, by the way, because
even he himself, he has resigned.
It goes for either side.
It does.
Now, the main point of contention with this law, because whatever else that has been passed by Parliament is procedurally okay, because we have been undergoing a process of professionalizing the UPDF, even the position of CDF as the head of the army, and delegating some of the duties the president held before to the CDF, and everything else is perfectly okay. And any government, any sitting government, would come up with policies and laws that align with whatever they want to do. Now, the main point of contention in this particular law was, as raised by the opposition, is that they weren't given substantial time to respond or to make contributions towards this particular amendment. Then for the lawyers, it is mainly about the issue to do with the trial of civilians in the courts. Because if you look at the issues vis-a-vis the trial of army officers or the rank and file of the UPDF before the court martial, I believe no one would contest that, even the members of the opposition. Because the trial of UPDF soldiers,
even that is
for disciplinary.
Even that is contested, because if a soldier has murdered, our view is that he needs to be tried by a competent court. But on matters of discipline, you've seen police, they have their own discipline court.
A tribunal.
Yeah. So we actually, our view was encompassing that even soldiers, as the court itself ruled, should be, except on matters of discipline, should be tried by the same courts.
That's perfectly fine, Honorable Ssemujju. The issue here is issues of discipline. Now, the government, the Attorney General actually, raises issues to do with the trial of army officers and co-conspirators or people who may connive with UPDF officers to be tried under this particular court. Now, the essence of the amendment is to ensure that it is realigned with the recommendations of the Supreme Court. Now, the problem with that particular judgment of the Supreme Court that was delivered in January is that they left an opening for the government to amend the law to enable or to allow civilians and army officers to be tried before the court martial. And that's where the president and the government actually has been pushing for. Because for them, they're saying, in as much as if you read, I think last evening, there's a statement that was released by the army, for instance. They're talking about issues. Colonel Chris Magezi, he's the spokesperson, he's the director of defense information at the Ministry of Defense. He raises issues to do with subversion, to do with treason, and issues of rebellion. Now, perhaps they have intelligence, which we may not be privy to.
They don't have, they're just a politician.
Of course, as a politician, as a member of the opposition, that's what Ssemujju is going to raise. But we may not know the real facts.
I have Samson Lowens here, Michael.
Yes.
He's saying, if you look at paragraph G, it is not complying with what that ruling was. If you look at clause 30 of the bill, that says if you are going to take someone to that court, you need to demonstrate a lot that they should be taken to the court.
Yes, actually, there's a bit of ambiguity there, and it is what I think OO was raising, that should there be any issues, because I'm aware that actually the members of the opposition are actually going to court to challenge the law, because we have that avenue. Because
limited circumstances, and only after the state has completely demonstrated to the court by verifiable facts and by objective and serious reasons the need and justification for recourse to the military court.
Exactly. Now the issue there is
that doesn't seem vague.
Exceptional circumstances. Now, how do you define exceptional circumstances?
Not exception, under limited circumstances.
Yes, there should be limited circumstances within which a civilian should be tried before the court martial. So how are you going to define that? Because what the opposition and perhaps the legal fraternity is saying is that is subject to abuse.
But Oscar, we are not benefiting from this lawyer who wants to come to parliament.
Yes.
For you, what are you saying? You are Ugandan.
I'm a Ugandan.
Yes, but you are hiding the opposition, the legal fraternity. For you, what are you saying?
No.
Because when you come to parliament, you should be a value addition, whether you are NRM or
when I'm talking about the legal fraternity, as a lawyer, of course, I'm talking about the position we hold. And the position is, for as long as you have not defined...
Jacob is smiling, Michael. You know these are things NRM is going to give you a challenge with.
Yes, I get that.
You stop talking law and start talking NRM things.
Yes, I get that. Now the issue is simply one. Should civilians be subject to military law?
Benefit from your legal knowledge.
Should they be subject to martial law?
Yeah.
And I'm saying, under the law, civilians should be having their own civil court system, right? However, there are exceptional circumstances where you may find a civilian, especially in issues, for instance, if it's issues of treason, or murder can be under the civil courts, but now issues of maybe, let me say, treason, where there's an attempted coup or something like that. So should such a person go or be tried under a civil system, or should he be subject to martial law?
Have they been tried in civil system before?
Yes, it's been there, because we have people like Jamil Mukulu who are undergoing trial
previously.
Yes, and there's so many of them. But then the argument of the government is that such people should undergo martial law. And you see, that is the policy of the government as pushed by the president. And you see, the tyranny of numbers they have used in parliament to pass this particular law is what is disturbing the opposition, the likes of the Honorable Ssemujju.
Speak for yourself.
So, for as long as
a lawyer, you went to school.
You see, even myself, if I breach the law, and all of us are candidates, by the way, for that particular law, going forward, this particular law is going to will be amended going forward. But as is now, we have to go with what they have passed. Because that is the government position, and that's the policy they have pushed.
If someone attempts a coup and uses civilians in that attempted coup as backup force, should we say because those are civilians, put them this way, and then these ones go into the
military people? Maybe you are speaking from a point of no knowledge. The military, first of all, today is still committing people to the same prisons. We are with them. When I was in New Zealand, they were the ones.
No, this is not about prisons.
Why don't they?
This is not about where you go.
Just quickly.
This is about how we determine.
Jacob, let me ask
you mean a death sentence by UPDF is different from a death sentence by the High Court.
I want to ask Michael a question and come back to Opondo.
Yes.
Can court cases be expedited? Like such, the way they expedited the bill, can a court case say this, we need to get this done? I've had this discussion with Moses Piaraga, who wants the American system. Once they bring you to court, 6 days, case closed. Can a court case in Uganda be expedited?
Yes, court cases can be expedited. The problem we have is that we have a dysfunctional judiciary. We have cases of case backlog. I have a case, for instance, that's been in court for the last 7 years. But to this date, it has not been heard. So when they raise issues to do with, especially the trial of maybe like army officers, if for instance an army officer went and shot people in a village, we've seen people, for instance, in Karamoja, army officers being tried before that unit court martial. So the president, actually, his argument has been that if an army officer commits, for instance, murder, shoots people in a bar or whatever, then they try them immediately instead of taking them to the courts. You've seen Jamil Mukulu. How many years has he been in our civil court system? To this day, he has been there for so many years.
So how can that be cured? By creating a court
now that is
or
creating the court martial actually helps expedite this process. That's what they're saying.
Boys, supporters of Chagulani were arrested 4.5 years ago. They are before court martial.
Yes, so it boils down to our court systems, whether it be the court martial or the civil court system, where we have to basically change whatever we are doing. Yeah, because there's a problem in our mainstream judiciary. There's a problem now, like the Honorable Ssemujju is saying, we have a problem in the court martial system. Then these issues need to be addressed.
Go to the microphone.
I think we are discussing these matters superficially without going to the origin of the state, origin of the law. It's just like we are now saying. Yes. And
you tried to give it. So
that's good for your health. I mean ideological health. It's like in Uganda here, we think that people who speak English are the ones who are educated, are the ones who are knowledgeable, and yet it's not. So it goes back to what kind of state, what kind of country, what kind of society we are running. We say lawyers are knowledgeable, but we have heard from the lawyer. They say they are the ones interested in pursuit of justice. But so how come that people who are legally trained and appointed, well paid today, can delay cases for up to 15 years? How come? So I think we need to go back and say, what does the law intend to cure?
Nothing.
Law intends to cure problems of society, whether it is political, whether it is economic. And therefore, for me, at the stage we are, we need to find alternative means and system to address grievances in society. And at this time, I think we need court martial to try certain offenses, provided there are guarantees that there will be fairness and there will be justice. For me, and if you look at the UPDF court martial, by and large, it tries soldiers mainly. Civilians come as a, by the way, the ones who choose to take themselves into the realm of military actions. I have not seen, for example, the military court trying people who have committed Afri. Afri is fighting in public. I have not seen. So, but if you bring yourself into military action, surely where we are, to take the case of Somalia, supposing we don't have a court martial, and okay, wherever our soldiers are engaged in foreign countries, how would we try them in the civil courts in Uganda? And so for me, that should be the issue. Does this guarantee? If it doesn't guarantee, Ssemujju should go back to Parliament and cause amendment rather than running away from their duty of legislation. But each time they run away when they face defeat, instead of bringing alternatives, how to strengthen the law, they run away. And then they come to the radios, whoa.
Ask Katundu who remain. What success did he register?
Well, because he was in the extraordinary, you having fled.
You see, Oscar, the NRM approach this matter as an academic question. In Somalia, I don't know if they are out, we had 2 colonels who were charged for abandoning when Al-Shabaab attacked. They processed them, they are in Ruzira. We had another one. We have another one who was, but they were brought back here. They didn't charge them in Somalia. So for the court doesn't have to be in Somalia. People can always be brought back. It's not that it's the absence. We had another one who was charged for selling guns to Al-Shabaab. He was also brought back to Uganda and charged and sent to Ruzira. So let's not use geography, that they are far away, therefore there are no courts. Even those who have been injured, they are taken to Nairobi and elsewhere. So the points, because you see, Museveni pursues the military court for a different reason. His handlers come on radio and give a different reason. At the beginning of this parliament, Museveni wanted NRM MPs to remove bail. He had meetings, they refused. He said, okay, I'll find a solution. What is the solution? Military court. That's why they took their message. when the military court was...
you couldn't end this without bringing Besigye as a way of sympathy.
Because he has been in military court. This is the second time. I cannot bring you because you have never been before a military court.
Both.
But Oscar, except if
now
you
just reminding
yeah, because it is Museveni who summoned NRM MPs and told them you go and pass the law. Okay, Kagame. They went to Rwanda and Rwanda told them to pass it. But the one who told them was in Entebbe. Even the MPs were in Munyonyo.
The leader of NRM is also the leader of
even MPs were in Munyonyo. Abandoned the committee worker to run to Entebbe.
The only issue can be if you say NRM MPs when they go to the president lose the reason. Maybe that you can.
Do they go when they have it?
Yes.
That they lose it from there. I doubt.
If they didn't have a reason, you would have.
So you see, Oscar, that's the reason Museveni pursues this court. That if he has sent you there and he wants you to be in the prison for a full year, you will be there. Look at these boys of Noop. Some of them are from my constituency. Arrested November 2020. 5 years later, even the court martial that is supposed to be an alternative judicial system hasn't tried them. Not even one witness has been presented. And they are still there. I think now they are going to continue. Because the idea is that you use a military court as a political platform. If you don't like it, because look at the case of Besigye, very interesting case. He is brought because in the law they have said if they have put aiding and abetting, if you are aiding a military man, and I think they force for Besigye, they pick Captain Ora, who was in Luzira for a different offense, and add him on Besigye to make it look like Besigye was aiding a military man. Samuel Ngora, former minister and former NRM vice chairman Northern Uganda.
No, Samuel Ngora was never. Samuel Ngora, yes. Former chairman.
So you mean everything from me you're going to deny, even when it is true? That's how you have tuned. That's how you have tuned yourself. Samuel Ngora, former minister, former NRM vice chairman Northern Uganda. We have been meeting in the court martial. He has a relative there who was arrested together with Ora. They charged them for trafficking something. I don't remember the offense. This woman is in Ruzira. When we were arrested protesting, going to the Kenyan embassy, the Ingrids were taken to Ruzira. So the woman was there crying. She said, but my co-accused now has been donated to Besigye. I don't know if I will ever go to court.
Yeah, but
so
was she proving that her co-accused could have committed another?
I am telling you the circumstances. The interpretation is yours. What Museveni will be doing is to pick a corporal and he says, Ssemujju, you are aiding a corporal, because the intention is not to try you. The intention is to keep you in jail. And
how come you haven't been kept there?
Even I mean, when they are killing people for you survive, they didn't kill everybody. So you mean Museveni has prisons for all Ugandans? Ruzira itself, the capacity is 10,000. It has
yes. I want to change subject now. So,
yeah. So let's look at the intention of the main sponsor of the bill and why he wants it, and then a number.
So your argument is create an impression that there's bail when there's actually no bail.
Actually, that's what will happen, because even when bail is granted by the
civil court,
normal court, in the case of Alan, I was in Masaka, Alan and Segirinya. The High Court judge said these are MPs, important people, they will come and report. Then they brought another judge and he said these are important people who will interfere with the investigation. So when Museveni was done, nothing changed. They just told them after 2 years and 6 months, now you can go. And they went. Because Museveni he doesn't want to use courts for justice. He wants to use court system and the judiciary for punishing people. And to him, you are guilty until you have proven yourself innocent. So that's why he has been...
We don't use the French system.
So...
let your Besigye acquit himself by giving evidence that wasn't involved.
But the government has no evidence. For 6 months, in Nakawa they said they have filed an application to use Besigye's phone to look for evidence.
We passed that law. That we can't.
Museveni said that you people who are crying for Besigye, why don't you cry for speedy trial? For 6 months he hasn't been tried.
We passed that law that if we want to use information in your system we should apply to court to obtain that information.
Opondo, you are being simple. You have arrested someone, you have no evidence. Why don't you first get evidence?
Yes, you collect the evidence and you
Yes.
arrest.
No.
So you arrest and then begin looking for evidence.
No. That evidence is available, but in order to present it in court, we need to extract formally with the court permission. Why don't you allow? Why doesn't the person say, okay, here's my phone, get the information? Why do you think you people are?
You mean I surrender my phone to Museveni? Even mine, I will hide it.
Why? But you see, that's why there is intelligence. What we gather intelligence, we can use it without necessarily taking it to court, but we shall achieve the end result that we would have neutralized you.
Thank you.
Opondo,
Yes, please.
I hope you are not supporting arrest before finding evidence.